February 2025. New York, New York. You ever had one of those days where your inbox is a dumpster fire? Your team is one missed deadline away from a meltdown. There's someone crying in the bathroom, and you are seriously considering faking your own disappearance? We've all been there. But here's the twist. In New York, your employees can now file for workers' compensation because of workplace stress. That's right. Starting 2025, January 1, employees can claim workers' comp for extraordinary work related stress. And they don't seem to have to prove that their stress is worse than what's normal for that job. Governor Kathy Hochul signed, and I may have butchered her name, maybe Hochul. Kathy Hochul signed the amendment under Act 5745, the amendment, reiterating New York State's ongoing effort to support mental health in the workplace. It's a game changer. And if you're an employer, HR pro, or business leader, you need to understand what's coming. Welcome back to Don't HR Alone. I'm Rhamy Alejeal, CEO of People Processes. Where New York leads, California follows. And where California follows, well, 20, 30 states normally wind up there pretty quick. So this is an important update, even if you don't have employees in New York. How do you protect your business without infringing on your employees' rights and landing in a lawsuit? Does this law lead to an explosion of stress-related claims? And what steps should you take right now to get ahead of this? Buckle up. We're going to dive deep into this new law exactly and what it means for your workplace. Let's get into it. All right. Why should you care? Before this, only first responders could claim workers' comp for mental health issues, and only if their stress came from a work related emergency, a specific event. Now, every employee in every industry can file a claim in New York. But here's the kicker: the New York law doesn't define what counts as extraordinary stress. That's going to be decided case by case by the Workers' Compensation Board. Always a very employer friendly board to be in front of. So, what does that mean for employers? Expect more mental health related claims. Workers' comp insurance costs could go up significantly in New York, which is already one of the higher priced states. And HR teams need to rethink how they handle workplace stress and reports of stress going forward. This is not a New York issue. Let me reiterate. Other states are watching, and we could see similar laws pop up nationwide very soon. All right, let's break this down into 4 key areas you need to know. 1, what counts as extraordinary work-related stress? That's the big question. The law doesn't spell it out, which means every claim will be a judgment call by the Workers' Compensation Board. We know a few things. Employees don't have to prove their stress is worse than their coworkers. That's not the barrier. Stress can come from one event or build up over time. Employees will need medical documentation, but that doesn't stop them from filing a claim. So they could lose the claim or having no documentation, but they have to have some to actually win it. A core aspect of workers' compensation is that it's to make someone whole from work. So it does require that, for example, they not be able to come into work and therefore have fewer hours, right? Like if you were a police officer and you, I don't know, lost your trigger finger or broke your trigger finger on the job, so maybe you couldn't work the same way. Obviously, your medical bills would be covered. And if you wound up working fewer hours or getting paid less at work, then workers' compensation would fill that in. Mental stress, similarly, if you were to become so broken by your job that you needed to seek medical counsel, that would be covered by the workers' comp. And if there was an injury that led to you not being able to work as much, then the decrease in your wages would be covered by it. Think about high pressure jobs like an emergency room nurse or a corporate attorney. Their roles come with stress, it's baked in. The question is whether their stress becomes extraordinary. That's where things get really murky. Let's talk about maybe what the financial impact could be. Let's talk about the money, because let's be real, if workers' claims start pouring in, your costs are going to go up. The number one financial impact on an employer is simply going to be higher insurance premiums, right? The more claims, the more you pay. There's also an aspect of legal fees and compliance costs. If you contest these claims, get ready to lawyer up. It's not free. Finally, a potential drop in emotional distress lawsuits. That's one upside. Employees may file stress claims through workers' comp instead of suing for emotional distress damages. But not too many people sue for emotional distress damages, but this would, in fact, potentially lower that. The financial impact's a mixed bag, but the law is shifting risk onto employers from the employee. You might be wondering, does this mean employees can't sue you for stress related claims anymore? The answer is not exactly. The workers' compensation exclusivity rule, for those of you in the HR world and kind of know what this is, it means that if an employee gets workers' comp, they can't sue their employer. But there are two big exceptions. One, of course, if you don't carry proper workers' compensation insurance, don't do that. And two, the more common one is that if the employee claims intentional emotional distress, which is the majority of emotional distress claims, those are things like harassment, toxic work environment. That doesn't that doesn't limit it to workers' compensation at that point under the exclusivity rule. They may file a workers' compensation claim, and therefore you have to pay them the medical costs and missing wages. But if it's intentional, then it would rise to the level of a lawsuit, and that's where you would, emotional damage and uh, even though they could theory come back to work for you, they wouldn't, and you'd owe them money anyway, right? So while this law may reduce some lawsuits and some of the kind of advocates of the law are putting it there, you're going to need airtight HR policies to prevent claims from escalating. And I don't particularly think that it's going to result in a much lowering of that. If anything, because they're able to get workers' comp, it's going to kind of bring it top of mind. And the question will be, are they satisfied with that or do they feel like there's additional damage beyond there? So let's talk about what you need to do. This is where we get tactical. If you're an employer or an HR pro, here's what you need to do right now. One, update your workers' comp policy. Make sure your insurance covers mental health claims. They should. Okay. You should have seen this already. But if you haven't talked to your broker about it, drop them an email and make sure it's covered. If you're self insuring or on a comprehensive, complex plan, multi state, maybe they don't know, they don't have it in there. If you have any sort of kind of, I've seen some collective plans that maybe don't cover this. You just need to double check and make sure your workers' comp covers this because otherwise you're on the hook. One of the legal articles I read on this is that it may be important to start documenting stress triggers like excessive overtime deadlines or management issues. If a claim happens, documentation is your best defense. I'm not exactly sure what that entails. One lawyer I was reading who wrote an article on this was saying that you want to start thinking of it like a hurricane, right? So there's like the day to day stuff that would damage your roof. But if you have any major events where everybody in the company or a bunch of people, like a team, is working super late for days at a time, you may want to go ahead and you may want to look at some sort of system to trigger or to look at these sorts of triggering events. Why would that help you as an employer? Well, proactive work would. So we'll come to that in a second. Another piece of that is that you want to review your job descriptions and expectations. Make sure that your job descriptions match the reality of the workload. If their employees claim their stress is beyond what's expected, extraordinary, right? Your job description could be your best evidence. So calm under pressure, multitasking, tight deadlines. If that's the job they signed up for, if that's the job you trained them for, you recruited them for, you asked them questions like, how do you deal with this? May not rise to extraordinary stress. That would be a very strong defense against that, we think, with the workers' compensation boards. But that's an important piece to go back to your job descriptions and your job advertisements, and even track, if you can, what questions you ask during job interviews, going back there. Like hiring somebody to be a lineman, running cables across the top of power lines, right? You need a steady hand. You need strong legs. You need to be able to lift heavy things and not fall off, right? Doesn't mean if it happens that you're not at fault, but it's going to really help keep it to, again, extraordinary claims, right? There's a physical aspect there, but it's similar kind of if you're thinking about a high stress job. Train your managers. A bad manager could turn a simple issue into a lawsuit. Make sure your leadership teams knows how to handle employee stress complaints. Okay? You don't have training on that. Let me know down in the description if you would like me to set up a webinar. I will cover handling employee stress complaints, the steps, what you need to document, what you need to let the employee do, what you don't need to do. Okay. Anyway, you can guess some of them. And finally, and this is, I think, probably the most important one, especially if you're a smaller business, you're much less likely to have this. Employee support programs, EAPs, employee assistance programs. are common and not that expensive to offer. They can have things like telehealth counseling, financial and life advising, like if they're going through a divorce and they need a referral to an attorney, if or they need mental health counseling because their parents are in bad health and they need support, or if they just need therapy, once a month or every 2 weeks. If they need to deal with these things, or they need advice on how to deal with an upset manager or an employee, those sorts of things are all part of EAP program packages. And they vary in cost. When you're a giant company, it can be very, very inexpensive. When you're smaller, we're talking $10, $15 a month per employee. This is 2025. Ballpark numbers. All right. Don't sue me. But getting a program like that gives you a great benefit you can talk about in your recruiting and onboarding and actually help your employees. But it also gives you a step in this, which is when things are stressful, you can remind people of the free resources or the resources you pay for, handle some of these work stressors. Okay. And head off, first of all, keep them from being as stressed and actually make them mentally healthier and more resilient. But perhaps more importantly, or just as importantly, right? Uh, Lower the potential costs of these things. Like I had a really bad day at work over the last 6 months every day. I needed therapy. I had to go get a therapist. It was $200 every week. If you can incorporate that into a workplace program, save you a lot of money. Okay. That's my key advice there. And if you need help with that, reach out. Again, you can book time with me if you're a US based business with 10 or more employees. If you're in New York and you only have five, I don't worry, just book away. Does need to be employees though, okay? You're 1099ing a bunch of people, you're paying people cash. I'm sorry, we're just not there for you yet. I've had a couple of crazy bookings in the last few weeks. But business owners, please book time with me, 30 minutes consultation. I'll walk you through this stuff. We can talk about people processes if you'd like to see if somebody can handle this for you, but mainly it's a consult. So you can just pick my brain. All right, back to the work. What's the takeaway? New York's expanded workers' comp law changes a lot of things. The definition of extraordinary stress is very murky, and one thing is clear: businesses need to be proactive. If you're an employer in New York or any other state watching this trend, you need to get ahead of this now. You need a plan. If you need help reviewing your HR policies, book that consultation with me. You want more insights like this? Please subscribe to the Don't HR Alone podcast so you never miss an update. And if you have a question, drop a comment below. I personally read and respond to every single one. We've had hundreds this year, well, last 2 months at least, and I've checked them out and I read them and I respond. I'm that guy saying thanks for the comment, even when people are very mean to me. Say something nice or mean, I don't really care. I'd love to hear from you. That's it for today. Thanks for tuning in to Don't HR Alone, presented by People Processes. Now go out there, take care of your people, have a great day, and get your work done.